Okay, well, thanks everybody for joining me again, and I, uh, I'm happy to provide the update that I can, although we don't have a whole lot of updates. The two things, and what I want to do is I want to dedicate a lot of this to question and answer so that you're able to ask me questions, and I can use most of the time this morning to give you the answers that you need. Which I'm happy to do and support the NSBA and support the members. The two big things, I guess, that that have been flagged recently are the Canada Emergency Response Benefit. This is the federal government benefit that they've put in place for people who do not qualify for employment insurance. There was a comment made by the Prime Minister last week saying that that it would be available to people regardless of whether they qualify for EI. So for a short period of time, there were people who were going to apply for both benefits, and I think some people may still do that. But the government has clarified that that Canada Emergency Response Benefit, which is the benefit available to employees for the period of time of the emergency, is only going to be, it's going to be one or the other. It's not going to be both. So people will either collect EI or they'll get the Canada Emergency Response Benefit. Now, the province of Saskatchewan has also created a benefit, a limited scope and limited time as well. But that one is a catch-all. If you don't qualify for any other programs, you can apply for the government of Saskatchewan benefit. That's on the employee side. For the employers, for the businesses, the news that came out of the federal government is that they've announced this subsidy program, the wage subsidy program. Now, when they initially announced it, it was 10% and it was capped at a total amount of $25,000. Now they have changed it and they've announced it so that it is capped at it will provide you with 75% of your employee's wages. And the way we understand it, that would be paid to the employer for them to distribute to the employee. They want you to gross up if possible. And it will be where the employee continues to work for you. So they'll pay you wages as long as the employee is continuing to work. This is a supplement. Now it maxes out at, it's for people it maxes out at 75% of $58,700 a year. So the numbers that come in are that you're looking at it's a cap. So anybody making over $58,700, or what it ends up being is it ends up being a payment of $847 a week that goes to the employer for distribution to the employees. Now, like I said, they encourage you to top up. If they're making more than that, if the employees are making more than that, you'd have to top up more than 25%, but that's what they've offered. Now, this is conditional. It will extend for up to 3 months. The wage subsidy will extend for up to 3 months. We don't know exactly how the application process is gonna work. I'm guessing the government is putting together a portal. They haven't given us dates on that. For the Canada Emergency Response Benefit, the first one, they have said that the portal is going to be available for applications by April 6th. We haven't really heard any more since that announcement. They have not given us a date for the temporary wage subsidy, other than to say that they're going to make it available soon. Now, whatever that means. The criteria that they've given us for this is that you are going to have to show a net decrease in your revenues of 30%. Now, how they are going to ask you to show that, whether they're asking for financials year to date, whether they're asking for financials year over year, how they're going to ask for that information, we have no idea, but they have put the threshold at 30% lost revenue. For some businesses, that'll be easy to show, regardless of the criteria. For others, it'll be more complicated. Once we have the criteria, we'll be sending out an update through the firm on how the criteria looks and how to manage your way through that process. We'll also be sending out an update once we have more information on the criteria or the application process for the Canada Emergency Response Benefit. I'm going to walk through it with a couple of the employees who've been laid off by various groups in the province, and just so I can actually see how the process looks. And same thing with the wage benefit once it's available. Now, the other thing that they did, that the federal government did recently, is they announced that the GST and taxes due on imports, so excise taxes, are going to be deferred until June. If you want information on that, I'd recommend talking to your accountant or your financial advisors on that point. Okay. I'm getting some questions here, so maybe we'll jump into that. If an employer brings back a laid off employee down the road, say April 30th, for the purposes of the question, will the 3 months of subsidy start from the return to work date? Well, to apply for the Canada Emergency Response Benefit, or to apply for EI for that matter, you need to be out of work. So you need to not have work available to you. So the 3 month subsidy, I'm guessing you're talking about the employer subsidy. Yes, the employer subsidy, it's retroactive to March 15th, 2020, and it will extend for up to 3 months. So in my mind, what that means is March, April, May, June. So you wouldn't get the 3 months of subsidy from an April 30th return date. You'd probably get 6 weeks. Now, they may clarify that and say it does apply for 6 months or for 3 months from whatever date you bring them back. But based on the information we have right now, my guess is that it's going to be, since it's retroactive to March 15th, it's going to be March, April, May, June. So those are that's going to be the 3 March to April, April, May, May to June. That's going to be the 3 month period. Let's see. The other question that I've got is that the 75% wage subsidy now replaces the 10% subsidy, and employers should not file for the 10%. That is correct. You would apply for the 75% wage subsidy once the application is available. You do not need to apply for the 10% wage subsidy. The government made a determination that the 10% was not sufficient. The 10% subsidy was not sufficient for the purposes of supporting Canadian businesses, and therefore they have moved it to the 75% subsidy. That's the so that is the that's the question that's come up. Okay. So that's the those are the main ones. The two main new announcements. Now the stuff on the provincial level, I mean, we've still got the 12-week layoff notice and the public emergency leave provisions, which allow employers to either send employees home to prevent or reduce the threat of the spread of COVID-19. And we have the layoff provisions, which allow for the 12-week layoff in a 16-week period. Now, as long as the state of emergency continues. Now, we've been getting a lot of questions on what does that mean? How do I manage this? What if I'm in a unionized work environment? There are a number of questions that have come up with respect to different work environments, and the the layoff provisions generally apply. What they do is they exclude the minimum notice payments under the Act for a temporary layoff. Now, what we're dealing with is temporary layoffs, not permanent layoffs. What your unionized environments and your collective agreements generally deal with is permanent layoffs, not temporary layoffs. But if you've got questions on your specific workplace, please let me know. I've got another question here. I read that this applies to nonprofits as well. What are the differences for reporting purposes between applying as a business or a nonprofit? Would they be required to show decrease in funding received for fundraisers, etc.? Your guess is as good as mine at this point. So initially, some of the federal programs were only going to be granted to small businesses that qualified for the small business deduction, nonprofits, and charities. They have changed that. This now applies to any employer in Canada, and they're gonna, but you have to meet that threshold. Now, we don't have the information. Nobody's released it. I've reached out to a few federal government employees, and what I've been told is they don't have the information. They don't know exactly how this is going to be, how the application process is going to look, how the overall analysis is going to be done, what you're going to have to submit. My guess is if you can show a net decrease in funding, or a decrease in gross funding, if you can show a decrease in donations, then you're going to qualify. Honestly, I don't think they've thought through all the details, and the nonprofit sector is a very good illustration, because likely a lot of the nonprofits have been granted their funding for the year, especially if it's coming from government. So that funding is not going to change. It's not going to be affected, especially not to that 30% threshold. And therefore, the question about whether or not you're able to show a reduction of 30% in your funding or your work is going to be, it'll be difficult to do. Now, I know a number of business groups have gone to the federal government and asked that the threshold be lowered or be clarified from 30% to something less, because showing a 30% dip in revenues is not an easy thing to do. And until we know more about what the actual application is going to look like, your guess is as good as mine. Looks like we have another one coming in here. Okay, so this one has to do with if an employer has to temporarily lay off employees due to COVID-19 due to keeping the workplace safe by reducing the risk of transmission of the virus, is the 1 week EI waiting period waived for them, even though they are not technically sick? So when the government initially announced, the federal government initially announced these programs, they said that the EI program was going to waive EI waiting periods, the 1 week waiting period, for people who applied on the basis of the coronavirus, on the basis of COVID-19. What we've learned since then is that that only applies where you're applying for sickness benefits. And some of the rationale that's come out from the federal government is that for people who are self-isolating, or because of travel, or because they've contracted COVID-19, or because they've been exposed to somebody who's contracted it, they did, and especially for the self-isolating for 2 weeks after travel folks, they did not want them to be required to deal with a waiting period, a 1 week waiting period. And so those are the people who it was intended to be waived for. Now that runs contrary to pretty much all of the press releases and announcements that came out saying that the waiting period would be waived for everybody. But the fact is that it is only waived where you apply for sickness benefits. Now, Some people have applied for sickness benefits based on being granted public health leave, which is where the employer requires the employees to go home to reduce or prevent the spread of COVID-19. That is a leave, not a layoff. And for that leave, some people have put in sickness, illness or injury or sickness benefits when they're coding the ROE for EI purposes. And to my knowledge, EI Canada, Service Canada has not been consistent in which ones they accept or reject. Few have been rejected for sickness benefits and told, no, you should have applied under the shortage of work provisions. And so you need to go get a new ROE and reapply, which is frustrating. But they have not been consistent in the way they've responded to those. And therefore, we're out of caution, out of an abundance of caution, I'd say use the shortage of work, but that does mean that you are stuck with the 1 week waiting period. Yeah, so that does mean that you're stuck with the 1 week waiting period. Those are some of the main questions that are coming up, and until we have more information on the programs, the federal programs that are being offered, it's tough for us to say what is going to qualify and what's not. Now, the other question that's come up, and this is on EI versus the Canada Emergency Response Benefit. The fact is, you can apply for EI right now, and you can apply for the Canada Emergency Response Benefit. The federal government indicated that all of the EI applications are actually going to be pushed into the CERB, the Canada Emergency Response Benefit portal, on a given date. We don't know how that's going to look or whether it's going to happen. But as of right now, if the employees are laid off, you will want to lay them off and tell them to apply for EI immediately. I know it's a pain right now, and there's a waiting period and a processing period. They simply can't process the number of applications that are coming in. There were over 1 million last week, and I'd be surprised if the number wasn't higher this week. And I think they processed maybe between 10 and 15% of those. So you can imagine what the backlog looks like on the EI level. Once the CERB portal is online, I'm going to be surprised if it doesn't crash a couple of times in the first few days, because there's going to be a huge number of people applying for that benefit at the same time. Out of an abundance of caution, if your employees are laid off right now, I would say have them apply for EI. And then once the portal is available, have them apply for the CERB. There's no harm in having them apply for both. And government will probably say, well, you only get one. And in fact, their recent announcements suggest that they're only going to get one. And therefore, but that doesn't mean that they can't apply for both. And with CERB being a catch-all for people who don't qualify for EI, including self-employed, so that would include people who rent space from somebody else as a contractor, they will qualify for Canada Emergency Response. I'm thinking there's a lot of those in the hairdressing sector and that type of work, where you're renting a chair. Those people will qualify for CERB, but they wouldn't likely qualify for EI unless they've been paying in as an independent contractor. Oh, I thought there was another question, but it doesn't look like it. Oh yeah, so the 75% wage subsidy does replace the 10% one. It's not in addition to the 10% one. So what I was talking about was the CERB versus the versus EI. Have them apply for EI right now. That's all that's available, and walk them through the process. There are a few provincial programs as well, but they're limited, and they're designed to be catch-alls if you don't qualify for any of the other programs that have already been made available. If someone received an ROE for sick leave because they are self-isolating and we lay them off when they return, do we amend the filed ROE to change it to shortage of work? If so, so it's going to be I'm assuming based on the question that you've sent them home on to self-isolate. We required them to self-isolate, so they are basically on a public health leave right now. And now, I'm also assuming that they've applied for some benefits. If EI Canada, Service Canada requires a new ROE to be issued, then issue a new ROE. If they don't, then they don't. But I would let the employee know as soon as possible that there is no work for them to return to, so that they can take the steps to continue their EI application and continue to receive benefits at the end of the period, at the end of the self-isolation period, if that's the case. So I would communicate that to them as soon as possible, and they can deal with EI Canada, Service Canada, to try and get the benefits extended. If they need a new ROE, yes, I'd issue one that says shortage of work rather than sickness benefits, simply because it makes it easier for the process to move ahead. But there's a chance that they'd be able to continue their EI benefits if they're laid off after the self-isolation period. So I would let them know that there is no work for them to return to, and have them go through the government process and make sure that their benefits can be continued. Hopefully that answers your question. Yeah. Okay. So that's the question on shortage of work. The biggest problem right now for people like me is that everything is a moving target. The advice that I've given on a number of issues has changed in the last 2 weeks, and any lawyer who doesn't admit that is lying. We are reacting to the programs as we learn about them. We're trying to figure out what is going on with the federal government, and we're trying to push for the best possible benefits, not just deferrals, but actual benefits that will allow small and medium-sized businesses to continue to provide services, and allow the big businesses that, especially the ones that have been deemed essential and that are continuing to continue to operate and to even staff up if they need to during this time. There's some that are able to staff up. So what we're looking at right now is the government is taking, both governments, the province and the feds, are taking steps in the right direction. So we've seen the feds move from okay, well, we're focusing on employees and we're focusing just on employee benefits, to okay, what do we need to do to try and keep some of these employers in business, especially the ones that haven't been mandated to shut down and are able to work even with a skeleton crew or even with reduced numbers. That how do you manage that? And so that's where this wage subsidy has come in, and we'll see if they make any changes to it or make changes to the 30% threshold in the next little while. I'm hoping they do. I think 30% is going to be an arbitrary number, and there's going to be some issues coming up with how do you manage that calculation? How do you actually submit that and show? Because if I take I can take the law firm as an example. I know that billings might be okay, but the revenue that's coming in from various sources is going to be down. Does that mean I can apply as a law firm for this benefit? If I meet that 30% threshold, I have no idea how they're going to do it. Looks like there's another question. Okay, this is one that has come up repeatedly with a number of employers. If you are in a situation where you have temporarily laid off employees and you are looking at permanent reductions. So you've said to them, we're laying you off for 12 weeks or for a period of time. And then you look at the numbers and you look at the books and you say, okay, we're not going to be, we've got 20 employees. We're going to have to be down to 15 when this all blows over because we simply cannot afford to operate with 20. Once you make that decision and you communicate, you need to communicate it to, once you finalize that decision, that is, you need to communicate it to the affected employees, and that puts you into the normal severance system, what we commonly call severance. It's notice or pay in lieu of notice for the employees. So what you need to do is you need to provide them with either severance or notice of termination, working notice or pay in lieu of notice. In these cases where they're already laid off, you'd likely be providing them with pay in lieu of notice. And that is a number. The common law notice or common law pay in lieu it's a range depending on a number of factors. So it's subjective. You need to do an analysis for each of the employees. The four big factors, the main one is still length of service, but the other three that you look at would be the age of the employee, the seniority of the position. It's easier to replace a frontline worker or first-line worker than it is to replace to find alternate work for an executive director or a CEO. That person, the higher level person, is going to take longer to find alternative work. And then the final factor is the availability of similar work in the area where the person works. So the courts are not going to require you to work, to move somewhere else to obtain work. So if you do have that situation where it looks like you're going to have to do permanent reductions, you will be taking a financial hit to do those permanent reductions because you will have to pay out severance amounts. And you will have, and right now, I mean, the overall test that the courts apply is how long is it going to take somebody to find other somewhat similar work. And they do have an obligation to go out and look for and try and secure alternate somewhat similar work. But with everything closed down right now, this is not the time for a court to be analyzing that situation because the prospect of getting alternate employment when a lot of businesses are closed down is slim to none. Now, the courts really aren't open or operating right now, so getting something in front of the court, unless it is an emergency application related to COVID, is virtually impossible in Saskatchewan. So the likelihood is that those matters won't be heard anytime soon anyway. But if you do have to make those decisions, like I said, they're on a subjective basis, and we're happy to help out or consult with whoever you use as legal counsel and talk to them about how do I manage these. But as soon as you made that decision, you need to communicate it, and yes, you're into the regular pay and lieu system. So here's another one that has come up. How do I deal with the wage subsidy or really any of these other situations for employees that are on commission? Now, commission salespeople are permitted in Saskatchewan, and some companies use the option of paying them a minimum wage. But for true commission salespeople, you're able to pay them 100% commission. So how do you calculate? First of all, the question was how do you calculate the wage subsidy for the commission salespeople? I would use their T4 numbers from last year and say, well, this person has made at least $58,700, which was the threshold, and based on them meeting or exceeding that threshold, you'd look at the the maximum benefit, the maximum amount that's payable for the subsidy. The other question that's come up on the commission basis is, what if I have employees who have earned commissions or earned commissions, I guess is the way I'll describe it, prior to a layoff date, but the sale is finalized, so their entitlement to the commission is finalized during the layoff period when they're laid off and they're not working. If they are assuming that they're still entitled to that, pay them when they're back. Pay them the commissioned amount when they're back. If the sale is finalized, and I'm assuming if they're laid off that the sale will be finalized by somebody else, they'd be entitled to that upon their return. Because they're on layoff, you wouldn't be paying them during their layoff period. Looks like there was one other one here. Oh, no open questions there. What about the other system? No, nothing new on there. Okay, so those, like I said, those are the two big ones. The next week is going to be crucial because we are going to see, now that we're into April, we are going to see some of these programs start to come online. Like I said before, my guess is that they will likely crash the first day, maybe the first couple of days, but people will be able to get their applications in for the Canada Emergency Response Benefit, as well as hopefully the wage subsidy stuff is up soon. The Prime Minister did say it was going to be soon, and he did say, he cautioned people not to try and abuse the system. I don't know how that, well, until we know how the system is going to work, I don't know how there would be potential for abuse. I've got lots of questions about the system, and this morning, this presentation has raised another good one on how do the nonprofits deal with it if they're funding based. How are they going to be able to show that they've got a 30% decline or they're affected? So, I mean, that's going to be, I don't know. I honestly don't know how the federal government is going to manage that and whether they've thought of this. In a lot of cases, they haven't. They haven't thought of the implications of placing that 30% threshold on there. And the charitables are often the same way. I mean, for the charitables, are you going to try and show that your donations went down by 30% or more in the month of March or the month of April? And when is the threshold date going to be? We have no idea on any of this stuff at this point. And it's a moving, like I said, it's a moving target. So we don't know what's, okay, first question here. Do you know if the CERB is only available to those with 100% reduction in income, or would someone that has been reduced to part-time hours and pay be eligible for it to supplement their earnings? As far as we know, it's going to be like EI, where you need a reduction in the full reduction in income. But like I said, we're waiting for more information. What I would recommend if someone is going to part-time hours or reduced hours is that you'd look at the wage subsidy, because the wage subsidy program is going to pay them up to 75% to that max. And rather than reducing their hours, try and apply for the wage subsidy and allow that to subsidize the total income. And that would give you the because that is paid directly to the employer, and then that comes in and it goes out to the employees, and you would top up. So even if you had them working part-time hours, it would almost make more sense to keep them on as full-time and work from home if possible, and apply for the wage subsidy. So the short answer is we don't know if it will apply to people that have been reduced to part-time hours. But there will be ways to supplement it either through the wage subsidy or through the CERB. We don't know until we've got more details. Next question, do you expect notice requirements for termination overall to increase due to lack of available work in the majority of industries? That's a great question because, like I said before, it's subjective. It depends on each employee. Some industries right now are not slowing down or not shutting down, and some are even ramping up. I wish I had bought stock in Zoom. I don't know if it's publicly traded, but I wish I had bought stock in Zoom if it is about 3 months ago. The notice requirements, the court's assessment, if these cases go to court, is it's based on the likelihood of finding alternate employment. Right now, with a number of industries completely shut down, yeah, I would say that the negotiations between employees who are permanently terminated and employers looks very different than it may have even a few weeks ago. So I expect if any of it goes to court, the answer is yes. The notice requirements, so your common law notice requirements will be going up. All right. Oh, no, that's not a question. Okay. So, I mean, a lot of these questions and a lot of these concerns are things that that because of the reactive nature of this, we haven't had a chance, and government honestly hasn't had a chance to turn their minds to. So there will be hiccups, there will be questions that come up, and we will have to bear with government, and you folks will have to bear with people like me to make sure that that we're covering off the advice that, like I said, has changed from last week to this week and is continuing to change almost on a daily basis. We are still putting out updates on and they are available on our website, including one today. But and we're going to continue to do so. The next big step is going to be the implementation of the CERB and of this wage subsidy. Until we know more about this threshold, the 30% threshold, there's not a lot we can do or say. Some of the other stuff that they've announced, like the deferrals and working with big banks and deferrals on penalty-free deferrals on GST and excise taxes, and the provinces announced deferrals on PST. Those are all somewhat beneficial, but really the only big program that they've developed on a federal level for businesses is this wage subsidy. And well, they now have extended it to larger businesses and not just the small businesses and the not-for-profits and charities. They've also put this 30% threshold on, and we don't know how that's going to look and what that means. I don't know how they can analyze that. Is there a drop dead date? Is there a cutoff date? Is it going to be as of March 15th? You have to show a decrease in revenues after that. Other than the businesses that have shut down, well, and for the businesses that have shut down, that have been forced to shut down, they don't have employees that are continuing to work, so the wage subsidy doesn't apply to them. That's the other kicker with the wage subsidy. The wage subsidy is available where you've managed to keep some or all of your employees employed. So you have to have kept your employees employed, and then you have to have this 30% deduction, 30% reduction in income. To make that determination, to figure out what that means, is going to be, I'm interested to see what the government puts out and how the application process actually ends up looking. All right, well, it doesn't look like there's any more questions right now. Andrew, you guys have anything that's coming up from internal for NSBA? If not, I can go through some of the older stuff as well. Again, I know in the last session I just did a very brief overview of the layoff rights and the public emergency leave. There is more than that has been available through through both the provincial government and the federal government. And we can look at a few of the items that both the province and the feds have announced. I guess the other issue that has come up in a couple of cases is whether or not you can declare your employees to be essential. I may have addressed this a little bit in the first seminar for the NSBA, but really, unless you're a frontline worker in healthcare, it's going to be very tough to claim that your employees deal with critical public health and safety services. That is what the threshold is. That's you can tell them that they perform critical health and safety services, but when push comes to shove, if this ever goes to a court and you're trying to tell me that your delivery driver is a critical health and safety service, I think you're going to be challenged on that. Depending on the circumstances, somebody who's delivering blood from Canadian Blood Services might be considered essential, but for the most part, you're going to have to look at the overall impact, and you're going to have to look at whether or not they're a frontline worker. In my mind, the critical public essential workers are going to be the frontline healthcare staff. Those will likely be the ones who would be flagged or could be flagged under that list. Let's look at some of the other programs that we've looked at. Yeah, I talked about the PST deferrals and audit deferrals without penalty in Saskatchewan. Those would be the big issues that are coming up are really the layoff and the public health leave issues. Even with government responses on it, it's still not 100% clear which is which and what rights different employers have. Employers have clearly been given the right to send employees home to prevent or reduce the threat of spread of COVID-19. That's the way that the changes to the Saskatchewan Employment Act for public emergency leave, or public emergency health leave, are written, that you are able to send employees home. Now, like I said in the last seminar, the position that's been taken by some folks, including Employment Standards, is that is a limited right, and it only applies where businesses have been required to close. If that's the case, then giving the employers the right to send their employees home is meaningless, because if it only applies to businesses that have been ordered to close by government, then they would have just put in there that government or the chief medical health officer is the only one that has the power to implement that. Another question. I have the answer is sorry. The question is whether or not somebody logged in late, and they have I addressed how a company determines the 30% revenue reduction threshold? Your guess is as good as mine. We don't know yet, and the question was asked earlier about how does this apply if you're a nonprofit, and if you're government funded, or if you're a charitable, and what is the threshold? What what is the drop dead date? What is the calculation date? Do I have to show that my revenues changed as of March 15th? Do I have to show that they changed as of April 1st? What am I comparing to? Am I comparing to January and February? Am I comparing to calendar year 2019? We don't know. All we know is 30%. And I don't know from a legal or a finance perspective how they're going to calculate that. I have no idea how they are going to manage that process or that program, because even if you set it at 10%, how do I show that? I can show you my month to month, and for some businesses where they've clearly lost work, or say the restaurants that are only doing delivery now, they'd be able to show that, but they at the same time are operating with a skeleton staff. They've had to lay off a bunch of their employees, so the wage subsidy for them is going to be applicable to a few employees in a restaurant kitchen rather than the entire front of house and back of house staff in a restaurant. So the threshold is there for protection of government from abuse of this system, I guess. But the reality is that this is only applicable where you haven't had to lay off your employees. So the threshold, at least at that level, doesn't make a lot of sense, especially with given the fact that we don't know how they're going to calculate it at all. Yeah, so we don't know. The answer is we don't know what the threshold's going to look like. Okay, that's really all we have for the updates. Unfortunately, there's not a whole lot more information out there yet. We'd like to have more. We'd like to have more information and more knowledge about how these programs are going to work. You can tell your employees that there are some other programs that have been made available or are going to be made available to employees. The GST credit, for anybody who qualifies for the GST credit, that's going up, and they will receive it directly from government. Childcare benefits are going up. I believe both of those are one-time payments that they have said are going to be paid out in May of this year, but that is those are additional benefits that are being provided by the federal government. In some cases, delays or moratoriums on payments like mortgages, tax filing deadlines, utilities have been announced in the province. The big banks have announced deferrals on mortgages, which means you push back your payments. Now, the big banks, if you're dealing with the banks, you need to check with your bank to see whether you're still paying your interest or whether interest is still being calculated. My guess is yes, it is. But if you defer, the other thing for employers, I guess the other thing that I can talk about a little bit is dealing with your landlord and dealing with rent. We're in a stage where some businesses have been ordered closed by the government. They would be in a position where we're dealing with something that's called frustration of contract. Frustration of contract is a legal term, but what it means is that the contract is unable to be performed due to something that is out of the control of both parties to the contract. That's exactly what we have here. The businesses have been ordered to close. They cannot continue to operate as a result of the government ordering them to close, which is beyond the control of both the landlord and the tenant, and therefore they cannot generate any revenue. When you get into that frustration of contract concept, when you get into that position, then the contract becomes the contract comes to an end as a result of that frustration. Now, what we're suggesting that people do is deal with their landlords directly. Talk to them directly and say, or if you are a landlord, talk to your tenants directly and say, how can we make this work for your business so that we can continue this, rather than having the contract. Because the problem with frustration is that means the contract comes to an end. Unless and until you negotiate something new, you're at the end of it. And so frustration as a concept is it's a tough one to deal with, because it brings an end to virtually brings an end to the tenancy. The other one that people have been raising is force majeure, which is usually it's a clause that has to be in your contract if you want to rely on it, but it allows for pauses or reductions or adjustments to rent or to lease payments if certain things occur. If you've got one of those, take it to your lawyer. If you've got a force majeure clause in your lease, take it to your lawyer, because they need to look at it. Those are specific to what's written in the contract, and may apply or may not apply in the current situation. I've seen force majeure contracts that are force majeure provisions that include things like strike or lockout, and I've seen force majeure provisions that only include very limited circumstances where you're dealing with public disaster like a tsunami or a hurricane, and they may or may not include this type of a situation where you've got the spread of a virus and a state of emergency declared. So if you're looking at that, look at it with your lawyer. Take a look at what the public emergency stuff actually says, or sorry, what your force majeure clause actually says. But the frustration of contract, that's definitely an option. I know a lot of both landlords and tenants have started negotiating and talking about, what does this look like if it extends for a month, 2 months, 3 months? Are we going to be able to manage? Are you going to be able to make some payments? Are we going to be able to adjust rent? That's the best way to approach these, is to go and talk to the other party and see what you can make work for the time being. The wage subsidy is not a rent subsidy. We do not have a rent subsidy at this point. The governments at both levels have kind of been hands off on that and have said, well, we're leaving that to people to deal with. Our main concern is keeping the businesses and, more importantly, the employees paid in some way so that they can meet their bills as they come due. So they're saying, well, we're offering to generate some, or place some money in the hands of the employers so that they can make these payments. The other thing that that the government has said, at least on a federal level, is that their understanding is that labor cost is the highest cost by far for most employers. It's not rent cost. So their priority has been labor costs, which is why they've designed the CERB and the wage subsidy programs to go to employers and employees, and why they've removed the waiting period for some EI applications. All right, any more questions? Looks like people are questioned out today, so we're getting to the tail end of this. If anything else comes up, feel free to reach out to me. If the newest update is not on our website right now, it will be by the end of the day, and we'll get it posted. It basically tells you all the stuff that I've told you today, and the previous updates are there as well. You can go through them and you can see how some of the advice and opinions have changed over the past 2 weeks, and will likely change again in the next week as they actually roll out these programs. So that being said, unless there's any more questions, I think we can. I can thank the NSBA for having me on again and putting up with me again. If any of you have questions, feel free to reach out to me either through the NSBA or directly, and I'm happy to work with you. But yeah, thanks for having me. Andrew, anything else that you guys need through the NSBA, or?
No, thanks a lot, Steve, for joining us again and giving some very valuable information to our members. I will just mention for everybody who is still on the line, our next webinar on Friday morning at 11 a.m. will be featuring Mayor Charlie Clark, who will be giving an update on behalf of the city as to what the city is doing to deal with the pandemic, as well as any discussion that the public wants to have with him. So everybody can tune in then, and that's sure to be an enthralling topic.
You should ask the mayor on my behalf what he thinks of the government, the provincial government saying, well, anything that you enact is not applicable.
Well,
Like they did
I mean,
in Regina.
that would be playing with political fireworks. So maybe we.
Maybe I'll ask that one
avoid
myself. All right. Thanks everybody for listening, and we'll if you've got any questions, shoot me an email or give me a call.